right is still right, even if you stand by yourself.
Mr. Chief Justice, may it please the court.
Welcome to this week's edition of Case in Point, the legal show for regular people. I'm your host, Sarah Parshall-Perry, a senior legal fellow at the Heritage Foundation in Washington, D.C. This isn't your typical legal show, and I'm not your typical lawyer, because I know the law can seem disconnected from your life and more than a little boring. And that's why Case in Point is for you, because our aim is to take away the mystery and the dullness surrounding that third branch of government, the judiciary, and show you why you should care about legal developments across the country. On today's episode, I'm going to talk the high-profile cases and most controversial pending petitions for review at the Supreme Court. Now, these are in addition to the cases that the court's already granted review on, from so-called gender-affirming medicine bans for minors, to porn and the First Amendment, to sex and sexual orientation, employment discrimination, and ghost guns, shaping up to be the Supreme Court's most controversial and highly charged term to date. I'm also going to talk to a lawyer, businesswoman, mom, and friend, Kim Herman, who is General Counsel and Executive Director for Southeastern Legal Foundation. She's been sharing trench space with me for years in the battle for women's equality and education, and that's all because of sex-separated sports, spaces, scholarships, and more within the confines of a law known as Title IX of the Education Amendments of 1972. Women are being edged out of spaces they secured more than 50 years ago. So we're going to talk to her about the state of litigation, why the law itself is illegal, and what her organization is doing about it. Pending cert petitions that you might want to know about. In a case called Boston Parent Coalition for Academic Excellence versus School Committee for City of Boston, a group of parents in Boston have launched a challenge under the 14th Amendment's Equal Protection Clause, that portion that guarantees all citizens equal protection under the law, to a racially motivated alteration of a competitive public school admission program intended to reduce the number of Asian American and white students in favor of other minorities. Now, you all remember the Students for Fair Admission case from 2023 at the Supreme Court and their decision. Now, remember, in that case, Students for Fair Admission sued Harvard College over its admissions process, alleging that the process violated Title VI of the Civil Rights Act of 1964. How? Well, by discriminating against Asian American applicants in favor of Black applicants. Now, Harvard admitted that it used race as one of its many factors in determining which students it was going to take, but they argued that its process adhered to the requirements for race-based admissions outlined in a previous case from the Supreme Court called Grutter v. Bollinger. Now, that case was originally consolidated for oral argument with the UNC case, but in the end, the Supreme Court issued a consolidated joint opinion. They found that, yes, the Equal Protection Clause of the 14th Amendment had been violated because both universities' race-conscious admission programs were unconstitutional under the Equal Protection Clause, and neither university could demonstrate that their racially motivated policies were driven by a compelling interest, or that that compelling interest in practice was narrowly tailored to fit that goal. So now if we see this case, the City of Boston's race-conscious admissions program at the Supreme Court, we've gone from universities to K through 12 schools. Once again, Asian Americans aren't faring any better than they did in higher education. Will the Supreme Court revisit Students for Fair Admission? Time will tell. But cert petition consideration, when the justices get together and make a determination about whether or not they'll pick this case up, is set for a conference on October 18th. Now, another really important case, one about which I am exceptionally passionate and have written a great deal. In a case coming out of the Seventh Circuit from Wisconsin, in the Parents Protecting Our Children versus Eau Claire Area School District case, This was a Wisconsin Institute for Law and Liberty case, as well as an America First Legal Foundation case. The lower court actually threw out the parents' claim based on standing, because the parents had claimed a challenge to public school secret gender transition policies. Now, we're going to talk about these later in the show with Kim Herman from Southeastern Legal Foundation. Is this an unconstitutional encroachment on parental rights? If teachers, administrators, and school principals decide to keep gender identity of minor students private and confidential from their parents, have they violated the parents' rights to direct the upbringing and education of their kids? Well, the lower court and the Seventh Circuit didn't get that far. They said the parents didn't have enough skin in the game and hadn't shown enough standing. The requirement that you have an injury that could be redressable by the court, and so they lost at both the lower court and the appellate court level. This case has now been reset for conference 3 times and is, just as with the previous case, reset for another conference on October 18th, tomorrow. Tomorrow could be a very big day for determining what the Supreme Court takes up, whether for parental rights, gender policies in schools, or race-based admissions, part 2. All right, so I am really excited to bring on Kim Herman. She's the executive director of Southeast Legal Foundation, but she's a warrior in so many constitutional battles right now, especially so in a fight that I'm also really passionate about, and that's the fight for women's equality, guaranteed in education by a law called Title IX of the Education Amendments of 1972. Now, Kim's been litigating since 2009 in areas of government overreach, free speech, economic liberty, and she is a real killer when it comes to protecting kids and education. But also she manages to do it all while parenting 2 little kids of her own. So, Kim, it is great to have you on Case in Point.
It's great to be here with you.
So can you tell us a little bit about the type of litigation that Southeast Legal does? What is sort of your bread and butter work?
Yeah, I mean, when the government violates Americans' constitutional rights, we sue them. Pretty plain and simple, right? Everyone goes to law school wanting to be a constitutional lawyer. Nobody thinks you can actually do it. So it's really just a privilege every day to get to fight for First Amendment rights, for equal protection rights, to make sure that government isn't overreaching, to really hold that administrative state to where it should be. And so those are just a few of the issues. And then obviously what we're here to talk about today, the fight against the Title IX changes and the fight to save parental rights across this country.
So that's a great segue, because I want to ask you a more personal question about your journey as a lawyer and a mom. There are people out there who could be listening who are themselves sort of trying to balance career and motherhood. And the fact that you're talking about parental rights, again, something I'm really passionate about, being a mom of 3. How do you manage to be both mom and public interest litigator and businesswoman at the same time? Like, you and I've talked about this, I can't tell you how many times, and it seems to be sort of a learning process that doesn't change, even though you are decades hence in the future.
Honestly, I have an amazing husband who is here every single day to support this work. He also believes passionately in the work that we do here at Southeastern Legal Foundation and across the conservative movement, grandparents. And, you know, I always say, and you've heard me say this a million times, Sarah, I wouldn't be doing this if there wasn't a need for it and if it didn't have to be done, right? I wouldn't sacrifice some of that time with my kids. And so we make it work, right? We as women, we do what we have to do to fight for this country and to fight for our kids, because that's really what we're trying to do here. We want to make America a better place for them.
So let's talk about Title IX. And Title IX, just for everyone who's listening who might not follow Title IX, I think everyone thinks mistakenly it's just the NCAA applied D1 sports law. It's just college sports. It doesn't have anything to do with anything else. But this is a 52-year-old civil rights law that is very short. You know, it's 37 words long. It simply prohibits sex discrimination in federally funded education programs. But a little thing from the Biden administration that was just released in April of this year, a new rule interpreting Title IX, did a couple of really significant things to a very simple prohibition on sex discrimination. So talk to me a little bit about what some of those changes were.
Yeah, so I was trying to not laugh when we said a little thing, right? 1,500 pages of a little thing. But the core of these changes is that the Biden-Harris administration is changing the definition of sex. So when you have a law that's been passed by Congress that prohibits the discrimination on the basis of sex, what sex means is key, right? It's the integral part of that law. And for 52 years, we've understood sex to mean biological sex. It's a male or a female, a girl or a boy. And now sex means gender identity. It means sex characteristics. It means sexual orientation. So they have changed the definition of sex. So you take any of those, plug it in, and now it discriminates, it prohibits discrimination on the basis of those things. And we're now looking at things from a subjective standard. So if somebody believes that they were discriminated against on the basis of their gender identity or their sex characteristics, they can file a Title IX complaint against somebody, and that person can be subject to discipline. And so these changes are really, really fundamental.
Yeah, they really are. And it goes to the notion of whether or not we believe the text of a civil rights statute actually means what it says it means. You know, this was enacted in 1972. It was the result of 250 versions of bills that went back and forth between House and Senate Workforce and Education committees. They had more than enough opportunity to say, okay, it's not just biological sex. It's also sexual orientation, gender identity or expression, sex characteristics, but they didn't. And even when it was reaffirmed and amended in 1987 with the Civil Rights Restoration Act, once again, Congress was not able to get an expanded definition of sex over the finish line. So for 52 years, sex has always meant male and female. So this is really sort of doing catastrophic violence to what we knew was always a plain text understanding of the distinction between men and women. And after all, we know this entire statute was the result of the women's liberation movement. One of the few pieces I think I would like to pluck from sort of the feminist history of the post-sexual revolution. We got educational equality, your grad degree, my daughter's volleyball scholarship at a D2 school. These were all results of Title IX. So to take that very simple term sex and to expand it in such a remarkable and unprecedented way really turns the notion of educational equality upside down. So now we're looking at sex-separated spaces, whether those are dorm rooms, housing accommodations, and overnight camping trips, whether it's sports, bathrooms, locker rooms, everything women have enjoyed in education. Your kids, my kids, has now been turned upside down. But there's more than just sex involved in this. And you do a lot of litigating in the free speech space. And you've written about, and I've talked about, how there are First Amendment implications in this law. So you think, okay, well, how does sex have anything to do with the First Amendment? So can you clarify that for the people that are going to be listening?
Yeah, I think the easiest way to understand this is to just think of a simple example. So let's say you have a 14-year-old daughter and she's at school and she has to change for PE, right? You go to PE, you dress out. So she goes to the locker room and a boy comes in to the locker room and he says, today I'm identifying as a girl. Maybe he's always has, maybe he never has, doesn't really matter. Today he wants to use that girl's locker room. She says, I'm uncomfortable with that. She asks to go change somewhere else. She makes any indication that she believes that he should not be in that girl's locker room. He can now file a Title IX complaint against her, right? So he can now go to the school and say, her comments offended me. And because they offended me, I now can't change for PE because I only want to use that girl's locker room. And now I'm being excluded from an educational experience, an educational opportunity, one class period of PE. And now your daughter could be punished. This is completely backwards. Like, everyone needs to really think about that. Your daughter can be punished for speaking out against a boy being in the locker room and speaking up for her physical safety.
Yeah.
It should be the complete opposite. Your daughter should have the right to file a sexual harassment complaint against any male that wants to be in that locker room. It
Yeah.
has completely silenced our women and our girls on our college campuses and in our high schools and lower schools, to be honest.
Yeah, and what I've found, I think, absolutely stymieing is that this administration believes that one individual's perspective, a biological male, is superior to that of a biological female. And so we can hear everything that we do about this administration being champions for women's rights. This rule, I think, eviscerates all of the rhetoric that we've heard from this administration since January of 2021, when this whole mess started with Biden's executive order on gender identity and sexual orientation. And it's only gotten worse. And the standard under this new rule, and again, for those who are listening, rules are interpretations of federal law. They aren't the regular process of going through the House and the Senate and then being signed into law by the president. These are supposed to clarify ambiguities, and they're governed by a separate law that we will talk about in a minute. But the standard here for the First Amendment is whether or not there has been more than, quote, de minimis harm to an individual based on their gender identity or gender expression. So if you fail to use an individual's preferred pronouns, if you misgender a student, you, whether student, teacher, administrator, can be slapped with a Title IX sexual harassment complaint. That's not only a violation of civil rights law, not only, as I said, does violence to this longstanding law, it's a violation of constitutional law. So there are two very closely related issues. When you start expanding sex, if you don't believe in the notion of biological sex being distinct, separate, immutable, you are unfortunately putting yourself up as a target, because we've got now the sort of toe the line, rhetorically speaking, or else. And so individuals are going to be muzzled from being able to express their sincerely held religious, moral, or philosophical objections, even to the notion of gender identity, which you and I know is subject to quite a number of, I think, critical flaws.
Absolutely. And the courts are agreeing here, right? So as you mentioned, we are litigating this issue right now. We represent Moms for Liberty and Young America's Foundation in a federal lawsuit. And the judge in our case found that this new rewrite does violate the First Amendment, because nobody actually knows what a person can say and can't say. And so they're going to be forced to self-censor, right? They're afraid if they're forced to use an incorrect pronoun, as you mentioned, are they going to be punished for that if they refuse to do it? If they speak after they believe in biological sex. And so our boys and our girls across this country are going to be silenced for those sincerely held beliefs. And the courts across the board, in our case, in the other lawsuits that have been filed, are saying First Amendment violation. Government, you cannot do this. This rule is unconstitutional.
Yeah, and we've actually also seen, and again, within this First Amendment concept, we're talking about what can be expressed and what can't be expressed. Now we're seeing this proliferation, and you and I've talked about these too, of gender confidentiality policies, right? So now we've got 12 million public school students who are enrolled at a K through 12 school where there is an overt policy of keeping gender identity information from custodial parents. If a child comes to an administrator and says, I think I'm actually a girl, I think I'm actually a boy. And the schools have overt policies to say, we're not going to inform the parents of this expression. Now, not only do we know that that flies in the face of 100 years of the Supreme Court's direction, its specific iterations on the importance, the primacy of that fundamental parental right, but it's also going to muzzle, and I feel sorry for these teachers, the teachers and administrators who go, well, it's a violation of my religious or moral or philosophical beliefs, a violation of the First Amendment that I have a right to exercise in lying to these parents. So now you have a twofold sort of monstrosity that you've created. And I think these gender school confidentiality policies are kind of this unspoken poison pill in this new rule that the Biden administration has just enforced. Do you feel the same way?
They are, and the schools here don't even have an opportunity to question the gender identity. And so, in that example that we talked about, when the boy says that he wants to use the girls' locker room, a school cannot say, "Well, let's talk to your parents. Can we at least see a gender dysphoria diagnosis, right? Like let's get to the bottom of this and let's see what locker room should you be using." Now, obviously, I believe, and we believe here, that if you're a male, you should be using the boys' locker room. But let's say a school even wants to kind of meet them in the middle. The school cannot even ask those questions. And then when they get that information, they can't share it with the parents. And so these poor teachers, right, they're going to be in this lose-lose situation where they're being forced to violate parental rights, or they're going to be forced to violate federal law, or they're going to be forced to violate their own constitutional rights. I mean, There's just no winning for our poor teachers out there right now.
So you talked a little bit about your case, and I want to kind of sort of describe a state of play for the people who are listening, because there are lawsuits all over the country. Within a month, I think, of the rules being published in its final form in the Federal Register, 11 federal lawsuits dropped in appellate circuits all across the country. So let's talk about your case specifically. Where did you bring your case? Who is your client? And what are some of the claims that you guys advanced in challenging this rule?
Yes, as I mentioned, our clients are Moms for Liberty and Young America's Foundation. And if your listeners aren't familiar with those two organizations, Moms for Liberty is a parental rights organization. They have over 130,000 members throughout the entire country. And Young America's Foundation is a membership organization with students at the K through 12 level, and primarily we see at the college level, just really advocating for our country and for our Constitution out there. And so we represent them. We also have 4 states that are involved in our lawsuit. So Kansas is the lead state, and other individuals that are represented by Alliance Defending Freedom, high school students who are athletes, and they want to fight against this. So that just kind of gives you the lay of the land of who are the parties in our specific case. And it looks similar in a lot of the other cases that you mentioned. We filed in the District Court of Kansas. And where does the court stand right now? The judge has issued a preliminary injunction. So the judge said, hey, Department of Education, we believe that this is unconstitutional and that the plaintiffs are going to win here. You cannot implement or enforce these changes at any school in the 4 states, or at any school where there's a member of Young America's Foundation or a child of Moms for Liberty. So we have effectively stopped this rule from taking place in schools in all 50 states throughout this country.
That is absolutely remarkable. And it's so interesting. We talked about this litigation before it actually was brought to the surface, when it was sort of in the early stages. We've been talking for months about how illegal the rule is. But I think it is so surprising that in that particular court, you guys have been able to affect really some of the greatest benefit to American school parents and to American school kids. And I know that there is a constantly updating list of colleges, universities, and K through 12 schools. For people who are listening and want to find out if their school is actually getting a reprieve, if the Title IX rule's been paused, where can they go to find that out?
Yeah, so I would say if you are a member of Moms for Liberty or a member of YAF, your school is automatically included in this injunction. And so the Department of Education cannot come in and require your school to change its policies. Or if a Title IX complaint is filed, they have to use the DeVos rule from 2020 for, I'm sure we'll talk about some due process concerns, but for the process. If you are not a member and you want to see what schools we've told the court about, you can go to our website, slfliberty.org, or the Moms for Liberty website, or YAF website. We've been having to give a list of those schools to the court because the court needs a way to enforce its injunction. So if you don't see your school on there, it doesn't mean it's not included in the injunction. It just means that maybe we haven't had a chance to give the court notice of that, but we are continuously updating that list and expect another one to come in about the next 30 days.
That is fabulous. What great news. So let's talk a little bit about whether or not the Supreme Court's going to weigh in. We saw what's called a per curiam order. That's an unsigned order. on which all judges agreed, 9-0, justices agreed. And this is significant, right? We've got some ideological differences between sort of the more liberal faction, the more conservative faction. This came out in August, within about 2 weeks after the rule went into effect. And two of the cases coming out of the Fifth Circuit and the Sixth Circuit went up to the Supreme Court because the Biden Department of Education said, listen, we know the lower circuits have already told us that one portion's illegal, but can we just let the rest of the rule go into play? And those were concerns on, like you mentioned, due process, for example, and definitions of sexual harassment. And all 9 of the justices in August agreed, no, these plaintiffs are definitely required to a preliminary injunction. The entire rule should be paused while the underlying litigation goes forward. So kind of 2 questions, and I'm asking you to sort of look into your crystal ball a little bit. But do you think we will get a merits determination? Do you think these cases will finally come before the Supreme Court on the actual sort of soup to nuts of the underlying rule's legality? And if so, what do you think the Supreme Court's likely to do?
100%. The Supreme Court's going to have to weigh in on this. This is one of those issues of federal importance. And so, obviously the Supreme Court will weigh in on a very small number of cases every year, but they will weigh in if there's a circuit split. So if the courts of appeals disagree on something, or if there's a question of really, really big federal importance. I cannot think of an issue that is in the courts right now, to be honest, that is more important from a national perspective than this particular case. And so no doubt they will rule. It'll just be a matter of how fast the cases go up there. There's a few cases that are going to be argued at the appellate level here coming up in the next month. Our case is shortly behind that. And so, I think all of our hopes is that by the end of June, we have a ruling on whether or not these changes are constitutional or unconstitutional from the Supreme Court. And I do think that the Supreme Court is going to side with us. The courts that have looked at this across the board have all agreed at the appellate level so far that this is unconstitutional. If Congress wants to change the definition of sex, then possibly they have the power to do that. There is no question that the Department of Education does not have the power to do what it is doing here.
Yeah, and we've talked a little bit about the fact that in a big case from last term, Loper Bright versus Raimondo Enterprises, the Supreme Court finally put a stake in something called Chevron deference. In other words, that judicially created doctrine that we're going to give the agencies, the executive agencies, the bureaucrats, the benefit of the doubt if there's any sort of ambiguous sort of determination of how the law should be applied or what it means. When in fact, they said, listen, we really ought to defer to the people who wrote the statute as opposed to those individuals applying the statute, because that gives executive agencies the power to make laws when that power was never delegated to them by Congress. That's why with such an expansive rewrite on the Title IX statute coming from this Department of Education, I think I too am pretty sort of hopeful, optimistic, cautiously so, but optimistic that once it gets to the Supreme Court, they will determine, listen, we've already struck down government overreach. Your firm knows full well exactly what this administration has done to reach over its skis and determine that it will take for itself power that it does not congressionally have. But I think I'm hopeful as well. But Kim, I want to thank you for coming on Case in Point. Thank you for the work that you're doing with SLF. We will be following your litigation specifically so with all of those individual schools, colleges, and universities that you now, in representing your clients, have been successful in gaining a reprieve for while this underlying litigation goes away. So thanks for being a killer litigator, a mama, and somebody who's in the trenches on this fight.
Right back at you.
Well, friends, that's it for this episode of Case in Point. We're hoping you learned something, were prompted to think critically, might have been entertained along the way, and found out what's happening in the law that might relate to you. Be sure to catch this week's and future episodes of Case in Point on all your favorite podcast platforms, Apple Podcasts, Spotify, Stitcher, Rumble, you know how it goes. And be sure to follow us now on our new and updated X account @CaseinPointPod. Share the show with friends who would use a little law in their lives. But until next time, friends, court is adjourned.